Interfering with reporting domestic violence in Washington state. What is it? Is it a crime? Does it apply in every situation? Well, if you're interested in that area of the law or you're dealing with something like this is the video for you. So stay tuned. My name is Lance Fryrear, and I'm a defense attorney in Lynnwood, Washington. My criminal defense firm has been defending people charged with crimes all throughout Washington state for more than 20 years. And we often get people charged with interfering with reporting domestic violence. So in this video, I'm going to cover what is the definition of the charge, when does it apply, what are some common defenses to the charge, and how do we deal with it if we're facing that charge. So right before I jump in, I'll just say, hey, if you find this video useful, please like and please subscribe. More people will get information they need. There's not a lot of informational videos out there. So jumping right into it. Interfering with reporting of domestic violence. We're going to link to the law in the description, but it's a pretty short law. It basically says that somebody who commits a crime of domestic violence, if they interfere with the victim of the domestic violence or some other person calling to report the domestic violence to law enforcement, or they stop someone from getting medical attention, or they stop someone from, having any type of, response from emergency services, stuff like that. So, if it's someone who takes the phone, no, you don't call the police, don't call 911, stop someone from calling 911, stop someone from going to the doctor after a crime of domestic violence, that's under the definition of interfering with reporting domestic violence. And so the interesting thing about the law, it does say affirmatively that there must be an actual act of domestic violence as an element to proving interfering with reporting of domestic violence. And so it's sort of a two-step thing. And so what's the level of the penalty? Is it a felony? No, it's not a felony. Interfering with reporting domestic violence is a gross misdemeanor. That means the maximum penalty is 364 days in jail and a $5,000 fine. So what are some situations where that type of charge can be brought? What are some situations where it applies? Well, as you might guess, the most common one is there's some type of dispute involving family or household members. That's what makes something domestic violence. A crime that occurs between family or household members is designated a crime of domestic violence in Washington state. And we have a video about domestic violence crimes, but basically family or household member, think about it as people that have dated, currently dating, currently married, formerly dated, formerly married, certain blood relatives, blood, sister, mother, father. The law is specific about how far it goes down. And it can also apply to people that have ever resided under the same roof, right? Without dating. You each live in a house where you rent a room, but you share a common space. Well, if there's a crime between those two people, even though they never dated, that's a crime of domestic violence. So the most common crime of domestic violence is assault, and usually assault in the 4th degree, any unwanted touching. So there's a shoving match, or there's, a pushing match, scratching, fighting, hitting, biting, throwing drinks, whatever. And, somebody says, I'm going to call the police. And another person tries to stop them from calling the police. If the police show up and they believe there's been a crime of domestic violence, and they believe that somebody, the defendant, usually who they believe is guilty of domestic violence, usually assault, tried to or attempted to stop, interfered with that person reporting the domestic violence, then they'll usually tack on an extra crime. Assault for domestic violence plus interfering with reporting domestic violence. So that's the most common situation. It doesn't have to be assault, the underlying domestic violence charge. It could be malicious mischief, which is damaging property. It could even be theft. If you steal your roommate's iPhone, that would be theft, domestic violence, believe it or not, even though there might not be any violence. So interfering with reporting is typically stopping someone from calling 911 It could be stopping them from running to the neighbors to report it. It could be stopping them from calling an ambulance or driving to a medical place for treatment. But most commonly, it's interfering with a 911 call is what we normally see. What are some possible defenses to that? Well, as you could probably guess from what I said to begin with, that there was no crime of domestic violence to begin with. I'm not guilty of domestic violence, so I can't be guilty of interfering with reporting of domestic violence. So the charges sort of track with each other. That is, if we can show that there was never any domestic violence, by law, there can't be interfering with reporting something that never happened, right? So a second thing that we can do is there was no interference, right? I've seen cases where the alleged victim says, the bad person, man or woman, took my phone. And the person gets charged with interfering with reporting, and then later the phone's found. They had the phone all the time. They were so drunk or so upset or so whatever that they just assumed that the suspect took the phone when in fact it was there all along, right? So sometimes we can factually defend, even if they have decent proof of a crime of domestic violence, that they don't have decent proof of any interfering. Yeah, sometimes it can be pretty bad. Sometimes the evidence can be against a defendant. You're on the tape and then you can be heard, put the phone down, and you're struggling for the phone. You're actively interfering with the report. Well, in those cases, we're going to get away from a factual defense as a way to help, and we're likely going to deal with the situation, right? What was going on? What have we done about it since then? Was there self-defense? Was there, substance use that we're treating now, right? We may not have an excuse because we never want to excuse, that type of bad behavior, but I think it's fair to explain and try to point out the things that we can do after the fact to try to, make sure that these type of charges don't ruin your life, right? Because, we want to, make the most out of a crisis and also do what we can to protect you going forward. So interfering with reporting of domestic violence, my opinion is it's usually an add-on charge. That's not usually a standalone charge. Most prosecutors aren't the most upset about that charge. They're usually most upset about whatever the primary domestic violence charge is. So oftentimes it'll get bargained away, stuff like that. We would still rather try to make everything go away if we could. And so don't get overly concerned about interfering with reporting. That extra charge, it can make it harder to negotiate, though, because if a prosecutor has an ability to dump one charge, they sometimes will feel more emotionally attached to making you plead to something else if they're going to dump one charge. So, but it's rare that I see that charge used to really change the sentence, right? We're going to give you extra time because of that. Unless you have a history of that, unless it's particularly egregious, the system, hasn't really been super strong on those type of charges. Nevertheless, you need an attorney, you need a public defender or a private attorney. Make sure you reach out to someone right away. Don't talk about the case to other people. Anything you say can be used against you, right? And if you find yourself in this situation, feel free to reach out to my office. My law firm's been defending people charged with this type of crime for more than 20 years. We deal with all types of crimes throughout the majority of Washington state. And if you give us a ring, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.